Hello and welcome to the Kenneth for Cam and Law Office Legal Podcast, the NJ Laws 2, looking at recent cases by the Supreme Court and appellate courts. This is in connection with the New Jersey Institute for Continuing Legal Education program handling drug, DWI, and serious motor vehicle cases in the municipal courts. We're looking at cases that were decided by our courts. And our first case deals with the United States Supreme Court. And in this case, it's a gang neighborhood at a traffic stop. It's a viable traffic stop. Is the pat-down of a passenger always prohibited? The answer is no. A pat-down during a traffic stop is permitted if there is belief that the occupant, who's a gang member, is armed and dangerous. And that's Arizona versus Johnson, 129 Supreme Court, 781, 2009. In this case, the court looked at the facts. While patrolling near a Tucson neighborhood associated with the Crips gang, police officer serving on the Arizona Gang Task Force stopped at an automobile for a vehicular infraction warranting a citation. At the time of the stop, the officer had no reason to suspect the car's occupants of criminal activity. However, Officer Trevizo attended to the defendant Johnson, the backseat passenger, whose behavior and gang clothing caused Trevizo to question him. After learning that Johnson was from a town with a crisp gang and had been in prison, the officer asked him to get out of the car in order to question him further, out of the hearing of the front seat passenger, about his gang affiliation. Because the officer suspected that the passenger was armed, she patted him down for safety when he exited the car. During the pat-down, she felt the butt of a gun. At that point, the passenger began to struggle, and the officer handcuffed him. The defendant was charged with possession of a weapon by a prohibited possession. The Supreme Court held that Officer Trevizo's pat-down of Johnson did not violate the Fourth Amendment prohibition on unreasonable searches and seizures, and that's Arizona versus Johnson. Our next case deals with motions to withdraw a guilty plea prior to sentencing. And what are the four factors that are required in the New Jersey Supreme Court in State versus Slater? Set forth four factors required to withdraw a guilty plea. Judges are to consider and balance four factors in evaluating motions to withdraw a guilty plea. 1. Whether the defendant had asserted a colorable claim of innocence. 2. The nature and strength of the defendant's reasons for withdrawal. 3. The existence of a plea bargain. And 4. Whether withdrawal could result in unfair prejudice to the state or unfair advantage to the accused. In this case, the court held the defendant Slater had met his burden and was entitled to withdraw his guilty plea in the interest of justice. And that was State versus Slater, 198 NJ 145, 2009. We all know that Miranda warnings are required prior to police questioning. In our next case, the defendant is called by police investigators and is told, listen, we're doing an investigation, we're looking into another guy, could you come down and talk to us? So the defendant goes to the police, he's given his Miranda warnings, gives a statement, and then he's told after he makes a statement that the victim made another accusation that was against you. The police start the questioning again without giving a second Miranda. Is the question admissible or the confession admissible? And the answer is yes, State versus Nehammer by New Jersey Supreme Court. In this case, the trial court did not err in finding, based on the totality of the circumstances, that Nehammer knowingly, voluntarily, and intelligently waived his Miranda rights under both the federal and state law. Thus, the trial court did not abuse its discretion in admitting Nehammer's confession to evidence. And that's State versus Nehammer, 197 NJ 389, 2009. Now, in many DWI cases, the probable cause that's listed on the police reports is some sort of lane violation. And the question the next case posed was, does weaving within the line without crossing the line justify a stop for 39:4-88? At least in the Law Division of Mercer County, the answer was yes. State versus Woodruff, drifting within a lane supports a DWI stop by the police. In this Law Division opinion, the judge construed the provisions of the lane violation statute, NJSA 39:4-88. The Law Division held it is not necessary for the state to demonstrate that weaving in a lane would affect the safety of other drivers. The court also held that 2 instances of observed weaving within a lane constitute sufficient reasonable suspicion for the officer to effect a motor vehicle stop of the offending auto, and that was State versus Woodruff 403 and J. Super 620, Law Division out of Mercer County. For additional information, contact the Law Office of Kenneth Verkaman, 732-572-0500. Other information on the web at www.njlaws.com. That's njlaws.com, and benotguilty.com. That's benotguilty.com. We're located at 2053 Woodbridge Avenue, Edison, New Jersey, 08817. In our next edition of the NJ Laws 2, we'll look at other recent cases in New Jersey by the Supreme Court and Appellate Court. Thank you.